Okay, well, welcome everyone. My name is Jay Lyman. I'm a librarian with the Seattle Public Library. So we're glad you're here at this program today on the patent process. So if you're watching this in real time, please like type your questions in the chat, or you can save them for the very end also. And do keep yourself on mute so that it doesn't interrupt the recording or the sound for others. And if you do end up, I hear some background noise, I'll mute you, but don't take that personally. Okay, well, I'm going to pass things over to my colleague, Professor Jennifer Fan. Thank you for being here, and thanks so much.
Great. Thanks so much, Jay. Hi, everyone. I'm Jennifer Fan. I'm Associate Dean for Research and Faculty Development at the University of Washington School of Law, and I also direct the Entrepreneurial Law Clinic. It's my pleasure to introduce to you today Jara Edwards, Acting Assistant Regional Director of the Western Regional United States Patent and Trademark Office. She's a supervisory patent examiner in TC 3700, managing a team of examiners in the area of medical prosthetics. After practicing as an attorney specializing in patent prosecution for several years, Jara joined the USPTO in 2010 as an examiner in the areas of computerized vehicle control, navigation, and robotics. Before becoming a supervisor, she served on several details, including GS-14 trainer for TC 3600, GS-14 Patent Academy trainer, and assistant outreach coordinator for the West Coast Regional Office. Jara received her BS in physics from the University of Maryland, Baltimore County, and her JD from the University of Michigan Law School. Also joining us today is Gautam Ubale, who's a primary patent examiner and the outreach assistant coordinator for San Jose Regional Office. We also have Anna Bakmefia, who's my colleague at the University of Washington School of Law, who serves as the assistant director of IP LLM programs and an affiliate instructor. And she helps me to run the Washington Pro Bono Patent Network. So Jara, I will turn it over to you. Thank you so much for being here today.
Thank you, Jennifer. Very happy to be here. Today we're going to do a pretty general overview of the patent process. So I will share my PowerPoint slides. And hopefully everyone's able to see first slide there. Okay, great. So there are quite a few slides here, and some of them I'll go through a little quickly, but I believe a copy of the slides will be available for you to view. Some of them are a little bit redundant, so we should be able to get through this in about a half an hour. All right. So we always have to give this notice that we're not providing legal advice. Here at the office, we do a lot of educational outreach, and we're happy to provide you with resources and other information, but we are not your lawyer, and this is not legal advice. We just have to give that disclaimer. So here's a little outline of what we'll talk about, the history and importance and different types of patents. We'll look at the front page of a patent to kind of get an idea of the anatomy of a patent. We'll talk a little about the application journey, which we call patent prosecution. When you hear prosecution, a lot of times you think of like criminal trials and that sort of thing. But this is that's just how the term that we use to refer to the sort of back and forth conversation with the office. And then we'll talk about pro bono legal resources and the patent and trademark resource vendors. So a little historical foundation. The foundation for patent law is actually in the U.S. Constitution. So you can see there that for a limited time, authors and inventors are given an exclusive right to their respective writings and discoveries. So that actually covers patent law, trademark, and copyright in that section and forms the basis for the laws that we have in the U.S. What's a little different about a patent from other rights that we think of is that it doesn't actually give you a right to do anything in particular. It actually gives you a right to exclude others from doing the activities you see listed here, making, using, selling, offering for sale, or importing the claimed invention that the patent covers. So it's a little more like keeping someone off your property. That's the sort of right that a patent provides. And most of the time, hopefully, you can go ahead and sell, the subject of your patent, whatever invention you have yourself. But sometimes patents will have a little bit of overlapping subject matter, and so um, someone who has a patent may be in a position where they actually have to work with someone else with a licensing agreement or something like that in order to be able to actually make and sell and use their invention. Um, and just to keep in mind, there are no worldwide patents. There are lots of agreements that countries have to kind of work with each other to help. Whoop, I'm a little ahead there. To sorry, to help speed up the patent process in a second country, maybe if you've already gone through it in a first. But as far as the actual coverage of that patent, it generally is country by country. And so once you have a patent in the US, that will only give you protection in the United States. So here are some different types of patents. You can see utility, design, and plant are kind of the overall categories. You'll notice that one in the middle is the Statue of Liberty, which actually was covered by a design patent. So a design patent is probably the easiest to describe. It covers the look of an item, so the ornamental design of a thing. And there can be more than one type of patent that covers the same invention. The utility is, as it sounds, it's a little more geared towards what the thing does, or exactly what are the technical features of the structure of that invention. Utility patents also cover pharmaceutical inventions, chemical compositions, and some other systems that include maybe methods and devices and have a combination of features. And then plant patents cover asexually reproduced plants. So one of my favorites is the Hass avocado because I love guacamole. But that's probably the least, the type of patent that I know least about because we don't have a lot of experience with those. But those are the most beautiful patents because those are actually color pictures. And you'll notice the other ones actually are usually black and white. There's a requirement to keep those pretty simple, but the plant patents are actually quite attractive. So the USPTO is the agency that's dedicated to fostering economic growth through, helping people protect their interests through issuing patents and creating a predictable and high quality intellectual property system. And that picture is our headquarters in Alexandria, Virginia. So why inventions matter? We've talked a little about promoting innovation, which, has that basis in the Constitution, but, helping companies grow, which provides jobs and all sorts of wonderful things that we can buy and use to enhance our lives, benefiting the community that way, and also providing personal growth, development, and advancement. And at the headquarters in Alexandria, we have um, uh, a little museum that also has the Innovators Hall of Fame. And a lot of times we meet inventors. Well, this was pre-COVID. We would meet inventors, just walking around the campus who were, just really proud that they were coming to the patent office finally after they received their patent. So it's definitely something that I think really enhances people's lives. So we have a couple slides here. I'll just breeze through these. They're basically just reiterating that same idea that IP-intensive industries are a benefit for, earnings, creating jobs. Those jobs tend to have better health coverage, tend to have more college graduates and that sort of thing. And this slide is another slide sort of emphasizing those same benefits of having a robust intellectual property system and all of the jobs created and that sort of thing. So here now we're getting a little bit more into the meat and potatoes of what a patent is. So the anatomy of a patent. So the front page of most patents looks pretty similar. Issued patents look a little bit different than you might also see published applications, but the same information is usually present. There'll be an issue date, or in the case of an application that's published, there'll be a publication date, and you'll see a number provided here we have an app. I don't know if you all can see my mouse, actually. I'm circling that application number, but it's sort of on the left column towards the middle. Okay, you can see my mouse. So there's the application number, which all applications get. There'll be a title, the inventor, which, hopefully is you all out there. Your name would be here. If you do assign your rights to a company or to someone else, that's listed. You'll see some data that has to do with what the examiner searched and where the application is classified. So that's always listed on the front. And that's helpful when you're initially looking for prior art in the beginning of your prosecution process. And we'll talk a little bit later about prior art and what exactly that is. But knowing where to look and what sorts of areas to look for other prior art, you can look at the front of a patent that maybe has some similar subject matter and see, oh, okay, here's where the examiner searched. There'll also be some references listed here, which are again prior art, which basically in a nutshell is other publications that are closely related to what you're trying to get a patent for. So things that maybe would prevent you from getting a patent because they already include that information or just very similar subject matter. And so you'll see listed here a lot of documents that were considered relevant, to this patent. And then actually we'll always have the examiner's name, and then usually it doesn't have the attorney name, but it has the name of the overall company. So the firm's name, not necessarily the particular attorney's name. Applications will also always have an abstract and usually have drawings. Not all applications have drawings, but on the front page, they'll usually pick one really representative drawing or two and put that on the front page. So that's a lot of information that you can find right there on the front page of a patent or similar information on a patent application. And what's really important for patent applications and issued patents is the claim. So the claims come at the end, but that's not because they're least important. They're actually really the most important part of the application in the sense that they define what the actual invention is. So there's a lot of, description of the drawings and things like that come before the claims. And at least in the US, we put the claims at the end. Other countries put things in a different order. So you can see here, this is just sort of a made-up application, right? This isn't a real one, but they've kind of populated it so that it looks like, a real application would look or a real issued patent. And then they've written a claim here. So in a claim, there's some legalese that you'll see very often. In this first line, we call this a preamble. You'll see this word comprising. And a lot of times the preamble will end with the word comprising, which basically means the same thing as including. And then you'll see this colon. And after the colon, all of the parts of the device or all of the steps of the method will be listed out. Usually there's not a dash there, but just for the slide purposes, they've added that to show you the separate limitations. So we would call each of these features a limitation. So you can see this chair has a seat, a back support, support arms, and a base. And the other sort of important aspect of the claims is that they generally describe how these different parts are related to each other. So the back support is attached to the seat. The support arms are attached to the seat and the back support and that sort of thing. And really, when there are legal questions about the invention or if you're looking at, someone who thinks, oh, well, you're infringing my patent, that sort of thing, it's really the claims that are analyzed. The drawings and the rest of the description are used so that we understand exactly what the claims mean. But really the claims are what defines the invention and what comes into question if there are, legal issues in the future. And I forgot. So this is just highlighting, have to click through. We talked about, how this claim is. Okay, so this talks about the patent process. So you'll start off, you have your new idea. So a provisional application, which as noted here is optional, doesn't require claims. So a provisional application is sort of a preliminary application that you can file in order to establish a date, because in the US, whoever files for that invention first gets priority. So if you and someone else have the same great idea and you both file for applications, whichever of you filed first will actually get the rights to that patent. Whoever filed second in the US is just out of luck. And I think most countries are harmonized to be first to file. We call it first to file countries. Um, so a provisional application, it should have as much information as possible that's going to be eventually in the non-provisional application, but it doesn't need to have the claims. But you want to have enough description in that provisional that there's support for the claim. And so a non-provisional application, you would have to file that within a year of when you filed your provisional application in order to still secure that date. So when you file your non-provisional application, it'll be reviewed as if you had filed it on the date you filed your provisional. Those two applications are linked together. So you get the benefit of the filing date of the provisional. So when the examiner is looking for prior art to see, did someone else already, publicize this invention, or did someone already file an application that's very similar to that invention, they'll actually have to find something that's before the filing date of the provisional if you filed one. So that's the benefit of filing a provisional. Now, a non-provisional does require the claims, and the non-provisional is the application that will be examined by an examiner and eventually issue into a patent. If it passes all of the scrutiny during examination. So this slide talks about the benefit of a provisional. So you have that 12-month window where you can still kind of refine your application a little bit and then file your non-provisional. You can investigate market potential, find counsel, and it doesn't require patent claims or an oath or declaration or an information disclosure statement. And I don't think we've talked about that. Information disclosure statement is just where if you already know of some publications that are very similar to your invention, then you have a duty really to disclose those to the office. So the IDS, as we call it, is just a form that you use to disclose those publications. So the provisional utility application is required to have a background, a summary, drawings, and a detailed description, and then there are some filing fees. And this is kind of covering that same information. Also, you can use a cover sheet, and there's some other information that you have to provide about inventors and correspondence address and that kind of thing. So this is highlighting the difference between provisionals and non-provisionals. So provisionals are used to establish that filing date because, in the US, the first to file is the one who gets priority. And again, there's no claims required. Compared to filing a non-provisional, it's definitely far less expensive. A non-provisional is not published and it's not examined by the patent examiner. And you have 1 year to follow up and file that non-provisional, which does get examined and also will be published about 18 months after it's filed. And that's the application that can result in a patent. And it is more expensive. There's different fees depending on the size of the company or if you're a solo inventor. And those fees I don't believe they're in the slideshow, but they're available on the website. But there's a pretty big difference for smaller inventors who are under a certain requirements, like if you don't have more than 4 patent applications filed already and that sort of thing. So that's worth looking into if you are considering filing an application and you're a solo inventor. And we can always, if you have questions, we can provide like a link and more information on that specifically. So who can be an inventor on a patent? So in the US, it has to be a human being. It can't be a company or it can't be an AI, but it can be a combination of people. So it doesn't have to be just one person. It can be several people. But whoever contributes to the conception of an invention, and that's a little bit of legalese. But basically, whoever helped solve, you know, gave a significant contribution to solving the problem or creating that structure. So in the context of, a lot of us that just work for a company and maybe we're an employee, if it's something where, all of the instructions were given to you and you were just following those very specific instructions, you would probably not be an inventor. But if you're the one who was writing the instructions to tell someone how to create a prototype or, how to perform a certain method, then you may be an inventor. But it is a little bit of it can get a little bit complicated as a legal concept. So that's one of the things that, when you do find an attorney or an agent to work with, they could help you know for sure if a particular person contributed enough to be considered an inventor. So first you need an idea, right? And the four categories that the US offers protection for are a process or method, you'll see that term used sometimes too, a machine or an apparatus or a device, a manufacturer, which is considered things like, um, why am I blanking on? Compact discs. I'm having I'm thinking tape, like I'm having a flashback to the 80s, but compact discs or DVDs, that's what I was trying to think of. Sorry. Um, Things like that where you're capturing code and storing code can be considered manufacturers. And then compositions of matter those can be chemical compositions, and pharmaceutical composition. So those are the four categories. So is your idea novel? So if you remember from that, back in the Constitution, that was one of the requirements, right? Was that the idea be novel, and also non-obviousness. So obviousness is another one of those legal constructs. But basically, the idea is that maybe it's not exactly, what you've invented. Maybe it's not exactly out there, but something out there is so close that it doesn't really seem fair or wouldn't really be reasonable to say that this is novel because it's so close to something else that's already out there. Or maybe, if you took one thing and just combined something simple from another thing, that would arrive at the invention. Well, if that's the case, then it's considered obvious. Um, and so, the definition is here, new was not described in the prior art. And again, the prior art is anything out there that's, already being sold or any publications that were already published before your filing date, which could be the filing date of your provisional or the filing date of your non-provisional. And then non-obviousness, if the differences are just, so routine or so sort of trivial that someone in that field wouldn't really consider those differences to make something be novel compared to something else, then it would be considered obvious. And that's part of what the examiner analyzes when you go through the prosecution process. They're looking at the prior art and comparing it to, what's in your application and deciding whether what's there is novel and non-obvious. So again, prior art, it can be printed publications, other disclosures. It can even be screenshots from a video on YouTube or something like that. Anything that's already out in the public before your filing date and that's reproducible, essentially, can be used as prior art. So it can even be, something on the shelf at Target. Someone takes a picture of it, to show that structure already existed. So the step 2 in the journey is presenting your idea, but you'll notice here this maintaining confidentiality is really important. Again, you may need to, get some funding. You may need to get some help from, an attorney or an agent, that sort of thing. But you'll want to be careful in general about disclosing the details of your invention to the public before you filed an application. So that's another reason why a provisional is a good idea, because you can hold that filing date and then you can go out and, you know, tell people about your invention without endangering your ability to file the non-provisional later. But if you have not filed anything, you have to be very careful, because even your own disclosure can kind of be used against you. And that's because once something's out in the public, it's not really fair to then later take it away, even if you're the one that put it out there. So there's a year grace period that you get, but if you know, 3 years ago were giving the details of your invention out, and then, you know, 3 years from then you file for a patent, that's too late, and your own disclosures can be used against you. So you'll always want to be careful in the beginning about, you know, the exact details that you're disclosing. And the next step is drafting the application. And we talked about this. There's sort of an exchange, you know, the limited time period, you get a monopoly over your invention, but you have to disclose it clearly so that when that time period is over, the public can benefit. And so some of the things that you'll want to keep in mind when you're writing your disclosure is you want to make sure you show that you were the inventor, that you understood all of the aspects of that invention. So where it says the inventor was in possession of the claimed invention, that's what that means. That's a little bit of legalese too, but you were not necessarily physically, they mean sort of mentally in possession of the claimed invention. Had you figured out the problem completely? Does your disclosure teach a person of ordinary skill in the art to make and use the invention, and this without undue experimentation? So someone shouldn't have to spend, you know, millions and millions of dollars to figure out some information that wasn't included in your disclosure. And does it describe the best way to carry out the invention? It doesn't have to disclose every single possible way of doing it, but it should at least disclose, here's the best way for performing this method, or here's the best way for making this structure. And this is, you know, along the same idea, just informing the public of the boundaries of your invention, just like with property. You know, here's the fence around my property, just so that it's clear what's yours and where the line is. Um, and then filing the application. So, oh, here, okay, we do have some of the numbers. So you can see, so I don't know if these slides have the exact criteria for micro entity, small entity, regular, but you can see there's a big cost difference. So that's definitely something that you'll want to look up on our website to see if you qualify as a micro entity or as a small entity, because it does definitely cut down on the costs of prosecution. So I think I'm almost at time here. So I'm going to go through these a little quickly. This slide is just letting you know it's not just a one-step process. So when you file your application, these loops are showing there's this kind of ongoing conversation with the examiner. You might receive something called a rejection, but that doesn't mean it's over. That's just the first step in that prosecution process. So you get a chance to respond to the rejection, which is this bottom loop here of maybe making an amendment to your claims, or making an argument. Maybe you disagree with how the examiner was explaining your invention or was explaining the art. So you get a couple of chances to go sort of back and forth with the examiner and make sure everything's clear and everyone, you know, understands things clearly, and make your case for your invention. And then hopefully, you know, that puts you on, you know, this little allowance boulevard here. But if not, sort of the ways that prosecution can end are abandonment. If you decide, okay, well, it's not worth it, you know, there's just too much other similar things out there. Or you can appeal to a patent judge and say, you know, I disagree with the examiner, and a panel of 3 judges will consider whether the examiner was right or not. And this process actually can be started again. So if you sort of get to the end here, you can also request to begin again with another round of prosecution, but of course there's more fees involved. So we've talked really about the role of the examiner. They search for prior art, evaluate the application for clarity, And another important thing that examiners do is hold interviews. That's a really good way. A lot of things on paper can be kind of confusing, right? So it's a good way to make sure that you understand the examiner's position and they understand yours. Um, so we definitely recommend holding interviews with examiners whenever it's appropriate. Um, and this is kind of explaining that same thing. So we've talked a little about this, the office actions. This is just a picture of what it is, but that's where the examiner tells you, oh, here's the art I found, or something in your application is unclear. Um, can you clarify it? And that's just a normal part of the process. I would say probably upwards of like 90% of applications will receive a rejection as a first office action. So it's not something, that should be off-putting. Or here's the statistics. Yeah. So 89 percent in 2021, 89% received a rejection. But then eventually 62% of applications were allowed. So a rejection is definitely not a point where you should give up. And then we mentioned this already, some after final options. And so there's a timeline. I'm going to skim through these a little bit because there's not really a whole lot of information. And quickly just highlight some resources so that we can have, oops, sorry, I believe Jennifer is going to also give some additional information um, about resources. So this is, we have regional offices at the USPTO. So this is just highlighting the different regional offices. A lot of what we do now is online, so you don't have to be near a particular regional office if you want to join a webinar or something that we have. And then we have this web page that has free resources, so that will link to some of our pro bono partners and PTRCs and also some of the phone numbers like the Inventors Assistance Center that you can call to get more information about your application. There's some more specific information about the pro bono programs and some of the requirements, for example, income below 300% federal poverty guidelines and all that. There's more specific information there. And we have a link for the Washington Pro Bono Patent Network. A little more information there. Law school clinics. We also work with a number of law schools to help provide low cost or free legal resources. Here we have a little map of all the PTRCs, which are wonderful partners also that can provide great resources and help provide information and help you with patent searches and all of that. And I think we're about here. There's some more, there's lots of resources. The webpage has tons of information. Pro se is the term that we use for someone who's filing a patent application on their own. So anytime you see pro se assistance, if you're a solo inventor and you don't have an attorney yet, definitely take a look at the pro se resources. And that's it. So I will now turn it back to Jay or Jennifer, who has some more information about pro bono services and PTRC.
Thanks so much, Jara. Really appreciate that terrific, informative presentation. I'm going to follow up on what Jara said and talk a little bit more about the resources that are available here locally in Washington State. So the University of Washington, I run, as I mentioned earlier, the Entrepreneurial Law Clinic, which is part of the USPTO Law School Clinic Certification Program in both trademarks and patents. So what this means is that our trademark and patent applications are actually seen on an expedited basis on at least the first go around. Because there are specific examiners that work just with clinics across the country on trademark and patent matters. So that's why we're able to get seen on an expedited basis. So Anna will put in the chat box a link to our application process and more information about the clinic generally. We also run the Washington Pro Bono Patent Network, which pairs low-income inventors with pro bono patent attorneys. So that is in partnership with the USPTO, and this is a program that we've been running for the past 6 years, or actually going on our 7th year pretty soon. And so Anna will also include information on that in the chat box. And as you saw, Jara had that in her slide deck as well. There's a last program, which I'll then turn over to Jay to explain, which is the Entrepreneurial Law Clinic Seattle Public Library Legal Consult. So we've been doing this since basically COVID began, in an effort to help entrepreneurs like yourself sort of navigate this entrepreneurship and legal world post-COVID. And I'll let Jay explain more about what we do there.
Thank you. So yes, I want to share more about the legal consults that we've been doing with UW Entrepreneurial Law Clinic. These are 30-minute sessions where you can book time one-on-one with an attorney who has expertise in intellectual property law or corporate law. So we have kind of two sort of types of sessions that we do. For the corporate law, we have available sessions this afternoon if you'd like to sign up for one of those. And if this afternoon doesn't work, we have more on in December 5th, I believe, is the next ones, and then we'll be announcing the dates for 2023 coming up over the next couple weeks. So we try to do one set of each per month. And I sit in on many of them, and it's a great place to get your questions answered and kind of ask some specific questions of an attorney who has expertise in this area of law. They're free, they're virtual. I'll put a link in the chat where you can sign up. Just select one of the ones that says either corporate law or says intellectual property law. And it says register, and it'll send you a link right away. In that same set of things, you'll see also other kinds of consultations. Some of those are with me or my colleagues, which are the business information appointments. That's where we're not attorneys, and so we're not going to talk about that kind of the things that you would get in those other ones. But we are researchers, so we're sharing our expertise as researchers of business information. So if you're trying to try to understand who's my competition, what are the trends happening in my market, or who's my customer for this service or this product, those are wonderful places for you to get those kind of questions answered. Okay, I think I covered that. Did I miss anything, Jennifer? What did I miss in that?
Nope, you got that perfectly. Thanks, Jay.
Cool. And then I'll also put a link to our other workshops coming up in case you haven't seen those. We have some on like business planning. We have some on building a website. A whole set of them on legal topics that we're also doing with the Entrepreneurial Law Clinic in the new year. So some of those are on the website already, some are not, and but I'll put a link to where they all live. And we have a lot happening between now and December 10th, and then more in the new year. So I'm going to put those links in the chat, and I guess we can open it up for questions. If why don't we go ahead and shut down the recording part of things, and then if folks have specific questions, they can ask them out loud. That way we can kind of, if folks are shy. So we're going to say goodbye to those that might be listening to this after the fact. And thank you for being here for those who are here right now. And so thanks so much.